the law firm side because I don't know as well how that works, but certainly performance management is huge in this organization and in many commercial organizations. You know, if I'm not up to scratch in terms of how I'm presenting or being on top of my technical skills, then I wouldn't be in this job. And that goes for all of my lawyers. And I will manage my team to a performance standard that I think is absolutely appropriate. And that has got to be the highest standards, because all my clients are here. My clients are internal. And so they see me every day. They see the team every day, and they have to abide by the highest standards, whether that's ethically, technically, advocacy, it could be anything. So I think performance management within commercial organizations is huge. And I don't know that there needs to be a bigger overlay. Similarly for the CPD side of things as well. You know, we are constantly on, you know, seminars, conferences. You know, we're constantly keeping up with the law firms in terms of what's going on in the market, in all the areas that we need to be upskilled in. Certainly my CEO and my board want to know that we are on top of everything, and we have to show that. So there is no scope for any of my team to be not on top of the technical areas that we're dealing with day to day. And we deal with regulators on a day-to-day basis as well, probably similar to Sarah and Charlotte. You know, so and they know these areas very well as well, so they know whether we're on top of that. So that there's an element of market management or stakeholder management, if you like, in terms of competency. And I think for me that very much kind of feeds into possibly the QC piece, but also the more general side of, you know, people will only have confidence in us based on our reputation, and that reputation has all of those aspects with it. And I think that goes a little bit to the, you know, the assuring ongoing competence. It has to be ongoing. You can't let it go. You've got to be on top of it all the time as things change, and things do move quickly, and they need the advice quickly. And I'm sure that's the same for the law firms, but I won't speak for Sarah and Charlotte.
I can tell you this, that ongoing competence, and not just competence, but excellence, is absolute first priority, because you simply cannot charge the fees that we do unless people really believe that they are instructing the best. And every associate is appraised twice a year, and it's a very formal appraisal assessment, and their work is examined by at least 6 partners, and everybody that they work for, and we know from who's been, you know, where the time is recorded, everybody has their opinion solicited on it, so you can't pick and choose. In terms of partners, I'm appraised every year by a panel of 28 partners. I have to fill in a 50-page form. All my matrices are assessed. And also, because I'm also part of the Office of General Counsel, our risk function, we know who is getting complaints about them, and we do the investigations and we manage that. So there's a very, very strong structure around appraisals. The complete opposite seems to be the case at the self-employed bar, I have to say. I see absolutely no ongoing appraisal whatsoever, and it's really becoming a serious problem. And it's particularly a problem at the silk end, because once you get silk, that is it. It's a quality mark, but there is no ongoing assessment of competence. And I have had so many bad experiences of, frankly, completely senile elderly silks who are being brought in at short notice on returns, or who are popping up in the international context, particularly in the Middle East, when they can't get any instructions in England. They turn up for these sovereign wealth funds. Nobody in those countries is in any way able to assess their advice and their ability. And we've had 1 or 2 instances where I've had to say to our associates, under no circumstances do you follow this person's instructions. I have seen correspondence that is bullying, that is sexist, that is racist, and I have taken it to the head of chambers, and I have said, what on earth are you doing allowing this person to practice under your brand? And I am told we can do nothing about it. They are a member of chambers in perpetuity, and they are a silk in chambers in perpetuity. So I think there really are serious concerns around that. And the self-employed bar constantly tells you there is no issue. I can tell you, as someone who spends £50 million a year on counsel, in what should be really good chambers, there is an issue around the lack of continuous appraisal and the lack of merit-based assessments at that end.
Well, I don't know if I can following that. I would wholeheartedly, you know, it was so powerful. I was just riveted. I would wholeheartedly echo every single thing that Sarah has just said, and particularly to the point that there's this real differential between employed practitioners and ongoing competency assessments and our peers and colleagues at the self-employed bar, such that we have just lost a £160 million case from a core client by virtue of a QC who didn't do what they ought to have done, causing an astronomical number of problems, and it's really mortifying, so mortifying. And yet sometimes to be seen as the self-employed bar's sort of less good sibling, to put it that way, is somewhat galling, considering the amount of rigor of the competency assessments that we have to go through on a regular basis, just constantly being examined and monitored. So I think there's maybe some learnings that our self-employed peers could take from us. I think the only slight caveat I would add to that, having sat on the YBC, is in terms of advocacy. And if you are a more junior practitioner entering the employed bar, there are generally ostensibly less opportunities to undertake advocacy unless you are employed by the CPS or a prosecutorial authority, or a kind of DWF advocacy or something of that nature. So there's a real risk that insofar as people want to maintain those skills, it's quite difficult to do so and to maintain that competence when you are a junior, and the qualified person rules do not seem to be drafted with that type of thinking in mind, despite it being a skill that's purportedly at the core of our profession for at least some. And given that there are more people from minoritized backgrounds at the employed bar, it ostensibly has a disproportionate effect on their ability to have a wide-ranging career and to perhaps chop and change and do different things, because well, it's not your issue that the courses aren't available, but it's not something that's picked up in a regulatory context. So you've got that additional push for those courses and support structure to be in place. The only one that I am personally aware of is Keeble, which is £2,500 for the civil course, and you'd have to take a big whack of time out of work, which might use up the majority of your annual leave, which you might not be minded to do, let alone the cost. So I think that would be the only caveat to the ongoing competency piece I would add.
Great, thank you. It's really interesting insights, and what really echoes with me is the difference in how the employed bar and the self-employed bar deals with ongoing competence and the seriousness with which they focus on ongoing competence. I mean, I've heard this before. I think there is clear disparity. There's obviously a lot of really good practice at the employed bar that that should be taken into account by the self-employed bar. I think there are pockets of good practice at the self-employed bar, but it's by no means consistent good practice, or indeed any practice in relation to ongoing competence. So we've identified that as an area of particular concern. So I'm pleased to hear that we're sort of heading and focusing in the right direction. I will come back to CPD if it's okay, and I'll also come back to the role of the employer as against the role of chambers in maintaining standards, because I think there are some interesting parallels that can be drawn there, and I'd like just to pick that up at the end. But Purnima, can we go into you talking to us through early years of practice, qualified persons, new practitioner program, etc., please? Thank you.
Yes, right. So I'm doing the early years of practice project, and in this project we are looking at what support new practitioners need in their early years of practice, and whether the current rules and requirements relating to early years of practice are fit for purpose. So today we want to understand what issues those new practitioners at the employed bar are facing, to try and understand what support is currently available in general and specifically through the BSB rules and requirements. For example, the 3-year rule, the QP rule, and the new practitioner program. And try and explore what further support might be needed by new practitioners in the employed bar. So far through our engagement events, we know that employed barristers find it more difficult to comply with the QP rule, as there isn't always a barrister who meets the requirements for a QP readily available within the employed setting. And we have also heard from employed barristers that the new practitioner program is geared more towards those who are in self-employed practice. And I think this echoes to a certain extent what you have been talking about, Charlotte. So to start off with, what I would like us to discuss is what challenges new practitioners face within the employed bar. And you have mentioned some of those issues already, Charlotte, but if you could expand on some of that a bit more, and to try and understand what support is currently available to address those challenges. So if I...
Sorry, as regards to support, I think it's distinctly lacking. I don't know what it is. I'm not aware of it. I was just really lucky that when I left Chambers and went into the Bank of England, that there happened to be, perchance, a qualified person with that satisfied the relevant requirements. But I think it is exceptionally difficult to find a qualified person that satisfies the BSB requirements. And I think there's a bit more of an existential, fundamental question about what are you trying to achieve with that particular rule? Because quite frankly, I happen to have someone who is very happy to speak to me about things going on in my practice, but oftentimes people will find a random individual who happens to fit the sort of administrative or bureaucratic sort of criteria, but that actually provide them with no substantive support whatsoever in their day-to-day practice. And particularly sort of at the employed bar, that can be really material to your development. And I don't mean to harp on about sort of those in more vulnerable categories, but you can stymie someone's entire career from the very outset if you do not have the right support in place in those first 3 years. Because if you're not developing those competencies, it becomes a vicious circle, because you're trying to move on and people are saying, well, why can't you do this? That's what we would expect of a barrister or an associate or whatever in the same position, or your equivalent at the self-employed bar. So you end up in nonsense positions, or I know quite a few people that have completely left the jurisdiction and left the country, or just quit the bar altogether because they don't have the right support in place. So I think some careful reflection about what you're trying to achieve with the qualified persons rule, and if the current way that's made up is the best way to achieve the stated aim.
Charlotte, that's really helpful, but also, sorry, Chris, I see your hand is up, but just very quickly, if I may take you back a little bit to first ask, what are the challenges you face as a new practitioner within the employed bar? So if you could reflect a little bit on some of the key challenges.
I don't think it's possible to give you a generic answer, because each employed sort of environment is different. Me working at the Bank of England is quite distinct. For working in a law firm is quite distinct for me working in a large corporate. But perhaps one common theme is that often as a barrister, you are sort of one of a very sort of small number. And therefore that isolation, as it were, gives rise to a need for a greater level of support, because we're trained in a certain way, which is perfectly fine and perfectly legitimate, but you might need extra support to navigate that particular sort of employed environment, which you probably will find to a degree from your organisation. But the unique thing is, how do you navigate that employed environment as a barrister in particular? So whilst your manager might not be a barrister, can help you generally with the corporate environment, how you navigate that as a barrister, what that means in as regards the cab rank rule, or where you see a conflict, or where there's SRA rules that I'm subject to, as well as BSB rules that I'm subject to. What does that mean in practice? If I'm in litigation and there's conduct of litigation issues coming up, what does that mean in practice? So it's those types of issues that will come up, and oftentimes the qualified person might be too far away from that part of their practice. They're just not, it's not something that they're doing on a day-to-day basis anymore. Maybe they're slightly longer in a tooth.
Charlotte, can I just quickly reflect on what you said? So it sounds to me from what you said towards the end that it's more that you need support around the technical side rather than pastoral care as such, or sort of mentoring, and the softer side, it's more the technical side. Is that?
Oh no, you certainly need both. I mean, I sit here as the only Black woman in the entire Pinsent Masons London office who's a senior associate. That's a difficult position to be in. And not only that, I'm the only Black barrister I think they've ever had ever, and the only one to have been in this team. That I'm not a junior practitioner anymore, but those are the positions that I have found myself in. So there is distinct need for that pastoral support. And actually, when in chambers, I had that much more and to a greater degree than I did in an employed environment, just simply because there are more people that could empathise with the position in which I found myself in. They were all other barristers in a set of chambers. They understood that. Whereas now I'm in an environment where people have qualified in a completely different way. So they see me as somewhat alien in a whole manner of different sort of ways. So, you know, you do need that pastoral support is absolutely material, particularly when you're at the beginning and you're much less sure of yourself.
Sorry, Charlotte, if I may just follow up with one further question. Sorry to focus on
No, that's fine.
But when you mentioned the more technical side of things, like, for example, how does the cab rank rule apply in a certain situation or certain ethical situations or conducting litigation? Do you feel that for those issues, the QP rule has supported you in any way?
Lol, no. No. I mean, I'm lucky that just in terms of general sort of someone, the person that I was supported with had a wonderful career at a commercial set of chambers. So generally speaking, as regards financial services, shiny and wondrous. In terms of providing responses to those questions, I sought them myself, which is precisely why I joined Bar Council and got elected, because I wasn't able to find the answers to questions, and neither was I, in particular, the bank with respect to pro bono. I've been banging on about that for 5 years because no one was able to provide me with the answers. And I still now get enough ethical queries into my inbox, and I'm sure Sarah and Gaynor do too, to know that clearly something is not working, because you shouldn't be asking me this. And the ethics hotline at Bar Council isn't working for you, so you're having to come to BACFI or the EBC, or people that you happen to know who happen to be at one with the BSB handbook, vaguely.
May I sort of check with others if there's anything you would like to contribute to that sort of general question around what are the challenges new practitioners face?
I don't think from my side, I mean, I think probably I speak for everyone in the context of, like, in my department, for example, in commercial organisations, it tends to be primarily solicitors, so barristers are few and far between. So from the perspective of guidance around the bar and how barristers conduct themselves and adhering to the BSB handbook, you're kind of on your own. You know, and some of those rules are not easy to navigate either. You know, I mean, the QP rule is not easy. You know, rule 2021 and the definitions are not that easy to piece together. And one example, I mean, even for myself, is that my practicing certificate has always said that I have rights of audience before all the courts in all proceedings. But yet this year, what popped up on my dashboard was that was with a qualified person, which I just don't understand. I qualified in 94. I'm definitely more than 3 years standing if you look at the rules kind of literally. So it's all very confusing. I don't think there's anything straightforward about it. And that's the most dangerous thing, right? If people are confused, that's where there's going to be issues, problems. You know, they're going to fall foul of the regulations unintentionally.
So based on what you have said, do you think the QP rule is useful to have?
Could I just say, is it maybe just to rephrase that, could it be useful? So I suppose that the question we are trying to get at is, and I think you quite rightly have identified to us some of the issues with the qualified person rules, and we are certainly live to that as part of this review. What I think we are trying to understand is what the challenges are for new practitioners, so that we can understand what needs to be put in place in order to support those new practitioners, and therefore if the qualified person, for example, in your experiences that you had to have because it was a regulation, didn't actually work for you, or in the context of the employed bar, it doesn't work, then perhaps we need to think about things in a much more flexible way. And what we, I think, are trying to get at is what the challenges are and what needs to be put in place to support those challenges, to support that new practitioner as they develop in those first few years of practice. And therefore, if there is a value of a type of support mechanism that could be a qualified person, but perhaps set up in a different way, whether or not that might be something that could be helpful, or whether or not you think that the employed setting already has the structures in place through, for example, line management, performance management, etc., that enables that new practitioner to develop their competences, and there isn't a need. So I think we're just trying to put that into a little bit more context for yourselves, and for you to kind of give us a little bit more feedback.
I think from my perspective that there is certainly a need. If there's one thing that I can say about my self-employed peers, is that them having those support structures, both formal and informal, are absolutely material to the development of their practice, their appearance in legal 500 chambers and partners and whatever. Oftentimes at the employed bar, it's very difficult to have those networks. And so I think the proposition that I made before in another similar call was that actually what would be more helpful, or what would have been more helpful, if there was some kind of register, almost like you have with private healthcare, where there is a register of qualified, suitable people, where you have their practice areas, interests, or what have you, so that you can find, or a person can be identified that can provide support. And perhaps external, can be internal to your organization, where it actually is meaningful and useful. Because sometimes, I mean, I personally have several mentors, and it's really helpful to have that external perspective, or to say, I'm going through sort of confidentiality permitting, but I'm having this type of experience. What do you think? Or I've come across this rule. In your experience, can you give me a steer? Because often a qualified person might not even at the moment understand your specialism. Financial services is really, really particular. So there was one person who had a pure criminal practice, nothing to do with financial services, but she was a qualified person in the bank, so not particularly helpful as regards to sort of practical competencies and things. So yeah, definitely I can see the need and a merit in it, but just not in the current structure.
Yeah, no, I agree. And I think we've got to remember as well, speaking again from the commercial organisation perspective, there's a large spectrum of commercial organisations, and some commercial organisations at one end will have one lawyer just one lawyer and will rely on external counsel for a lot of the work, but that doesn't mean that that person should not be sufficiently competent. They will still have performance management, etc., but they might not just be in the same level as, for example, I would be, or the large banks would be, or the law firms. So we've just got to bear in mind that you can't have nothing. You've got to have that support. And I think I'm not as in touch with the very junior end because I don't have any junior barristers, and that might be very telling in itself. The junior applications that I get are all from solicitors, no barristers. There's a whole other story to why that may be as well, in terms of the employed bar and how it's viewed and its worth, which is a different discussion. But I think that's important to remember. There is a spectrum, and there are some sole practitioner lawyers in that sense as well in commercial organisations that need support.
Given the time we have, this is really useful. Given the time we have, I think we should move on to quickly get your thoughts on the new practitioner program. Is there a need for the new practitioner program? Is there a need for a separate CPD program for new practitioners, which is different to that of established practitioners? And how can it be made more flexible to cater for the needs of those within the employed bar? So
I'm not as familiar with the new practitioners program, so I don't know, Charlotte, whether you are, but I'm really not, because I've always been established, unfortunately for me.
Yeah, I took the new practitioners program, and I think oftentimes I hear it characterized as, what can we do to be better for the employed bar? Actually, it needs to be better for the self-employed bar as well. It's not good enough that you're doing a course that doesn't encompass any of the skills that you need for the employed bar, because nowadays most self-employed practitioners, maybe they'll come and do a secondment, maybe they will decide to do sort of a portion of their career at the beginning at the employed bar and then pop back self-employed bar, or do dual capacity and all kinds of things. At present, the NPP that I took was not fit for that particular purpose. So yes, it was useful in terms of certain of the traditional skills, certain of them, and even then it was somewhat lacking. For example, if you have to spend time in upper tribunal, as is the case with financial services, none of that is covered at all. So if you decided to take a pro bono case, I saw a junior do the other day, you just go in cold, like you have no idea, none. And that is applicable whether you're self-employed, employed, or in between. So certainly at present, it doesn't strike me that it's fit for purpose, but I do think it is really important. And I had the full support of the bank. They're really pleased to see a specially tailored course because they want to make sure you're competent to do your job. But me feeding back that, yeah, you've let me sort of pop off on this thing, it was all right, but not quite what I expected, isn't ideal. So if we're a third of the professions, doesn't mean a third of people sort of on the employed side get a rubbish experience, but equally on the self-employed side, they're missing out too. So needs work would be my feedback.
So should we be taking an approach where we say these are the outcomes that new practitioners need to have met by the end of the new practitioner program, and leave it up to new practitioners to decide and source the type of CPD that they need? Or should there be specific, more prescriptive sort of modules or training areas?
I think given what Sarah said at the outset about where people find themselves at the more senior end, as much as I love sort of my peers and colleagues in self-regulation, I think we do need to be a little bit more prescriptive to ensure that certain core skills and competencies are in place, at least at the beginning. If we can't do it at the end, at least at the beginning, that certain things are assured, and that people can have the rounded and fulfilling careers that they quite rightly deserve, having dropped 20 grand, if not more, on their BTC and BPC, and probably gone into massive debt with their 100 grand worth of degree. So yeah, I don't think outcomes are enough. Because if you look at what people do with CPD at the moment, now that things are a little bit more fluid, I think that tells you all you need to know about what happens when you tell people about outcomes and don't give them clear guidance about what they really ought to be doing.
So what type of topics would you say are key to the new practitioner program?
I think in a modern, at the modern bar, a broader definition of advocacy and a different forms of advocacy that you are going to have to use. So not just traditional court advocacy, but as I say, whether it's before tribunals, whether it's before decision makers, and I don't just mean decision makers in regulatory bodies, if you are before a board of directors, that is a really different beast to being before the High Court. But that's an important skill to have, because if you're doing a secondment, you may be dragged into said board, or maybe you're a self-employed practitioner and they said, well, blah, blah's given the advice, which I've had happen. Bring them in. I want to hear from them. Why have they said this? Let's really probe what they said in conference, because this case has been going on for 2 years and I need to know the answer. And as a newbie, that's really daunting. And that skill set isn't taught. You just have to learn on the job, has been my experience. So it's those different forms of advocacy and different forms of, I think, particularly soft skills and material. Some of my encounters with the more junior end of the bar have been somewhat shocking, to say the least, as someone who procures services from them, in terms of how to deal with people, how to deal with professional clients and lay clients and corporates, and what is appropriate. Those are core skills. We're taught them in organizations, but it's something that isn't taught in a BPC, BTC, or necessarily during pupillage. So those are the two big things that I would really highlight for new practitioners.
Any other thoughts on that particular point from anyone else before we move on to the next?
I guess just an expansion of that is just to, my view has always been that training courses that have been provided, whether it's by the INS, by other organisations for barristers, have always ignored the employed bar aspect. And I think they really need to, because those skills are, this again carries through to other things like the QCA appointment system and the definition of advocacy and being before the courts. And, so that this all kind of links to the bigger picture of being able to progress in your career, and you've got to get it right from the start and have a broad view and a broad experience of everything that being a barrister could be. And that's not just in chambers. Chambers is one part of that.
So where do you go for training? I mean, or maybe another question is, have you discussed with the INS the prospect of a more employed practice focused set of training delivered by them?
Well, Lincoln's we just had, which I just was a guinea pig for, a presentational skills training with the Actors Guild, which was designed to teach a broader range of presentational skills with a view to a broader range of advocacy being undertaken. But I would really, really disabuse people of this notion that it needs to be employed bar separate from self-employed bar. There were judges in that room, tribunal judges, employed barristers, self-employed barristers, and dual practitioners. And this kind of elitism piece between a self-employed bar and employed bar stems from this differential that employed barristers needs to be carved out. No, my expectation, if I'm instructing you or working with you, is that you have equally as good skills as myself in appearing before any decision maker, whoever they may be. And it's not good enough that you're like, oh, I'm not at the employed bar, so I don't know. Not good enough. As far as I'm concerned, there needs to be a bit more of a collegiate and one bar approach to these types of courses. It's not about carving out or we're completely different. In fact, I've considered that at the employed bar, we almost need double the set of skills compared to some of our self-employed peers. Like, it's not just drafting particulars, it's not just doing the defense, it's dealing directly with your clients on a day-to-day basis and managing people and ensuring their competency and ensuring your own. All of those skills are material to a modern day barrister, and I expect to see the same in my self-employed peers.
And your clients don't leave you. when you're in a commercial organization. So your reputation follows you around. That, you know, you can't step away from it and just feel, well, they're not going to instruct me again, so be it. They are here, they are at my door all the time. So that's an important kind of competency point, I think, to take forward.
Yeah, and that soft skills of, with the case that we just lost, I have to continue to work with that client on a day-to-day basis. Whereas that self-employed practitioner is now, that their name is somewhat dirt, but that has a corresponding impact on me, and had perhaps that person had some of the soft skills training that I am advocating for at the moment, we may have had a slightly different outcome, because it's material to that person's practice as well.
Sorry, Oliver, do I have time to quickly ask about the feedback? Or...
Yeah, go for it. Yeah. No, you're fine.
So one final question, just wondering whether you sort of the role of feedback in all of this. So within the employed bar, what is the role of feedback from peers, from clients, from your managers, etc.?
It's constant. So there is no, I mean, we have a performance management process, but if something isn't right, it gets called out there and then. It's a constant feedback loop. And that's really important, because it's so easy to slip into bad behavior. If it's not called out, it's not picked up, then, you know, that's, and that I think is one of the strengths of the employed bar. We're constantly self-appraising, we're appraised by clients all the time. Very different from the self-employed bar, I think, from that perspective.
Yeah. Oliver, over to you for the CPD.
Yeah, I mean, just following on from that, I get the self-employed barristers that you engage, do you give them feedback?
Sarah does.
Absolutely, of course. I mean, our clients are usually pretty blunt to us in what they think of counsel, and of course we have to pass it on. Where we find things are particularly difficult is when you get clashes in diaries and things, and somebody covers the case, and you get somebody that you have no familiarity with. To give you an example, I sat behind somebody 6 months ago who I frankly did not have a clue what they were talking about. And I looked at the judge, and the judge clearly had not a faintest idea either. And when I spoke to the counsel we had originally instructed, who'd actually was taking it, came back to the case, they went, why on earth did they give you her? She hasn't had any work for years. And I think, well, we didn't know, we didn't know that. We trusted Chambers to cover the returns. So I think there is an issue around that. It is quite hard to give feedback. And the other issue is when these people are working, effectively become counsel to overseas entities. It's very difficult, because the relationship that they have is all about keeping in with that client, and being almost the quasi in-house, even though they have none of the same duties as an employee would have. That becomes quite difficult to give feedback, which is why I've often, when I've been really uncomfortable with behavior, had to go to the heads of chambers and been told, well, nothing we can do about it. That's just not, they're all self-employed. That's the way we work. So it's a very difficult one to actually give, feedback in the way you need to. That being said, when we've had really great counsel who has had a bad run of it, they are normally absolutely mortified and do absolutely everything they can to try and get you back. But the reality is, if you've had a bad loss, the client is probably going to change horses on the appeal.
Yeah. I was going to say, I think that feeds into the new practitioners program and qualified person piece as well, because as a junior and employed context, you're often given cases that are really, or matters that are really, really significant compared to what your peers at the self-employed bar might receive. So at the bank, I had some massive investigation. As at the beginning of my career, it's like 40 billion, like odd quid. And in those circumstances, you're told, well, go out and instruct someone that you think is good, and say that person isn't as good as you might hope. How do you then, because that someone is your peer, who's your senior, then turn around and say, well, you know, that wasn't so great for X, Y, and Z reason. I'd also like to maintain a positive working professional relationship with you. That's really difficult to navigate as a junior practitioner. Or if you're on a secondment, you've come in from a set of chambers and then you're having to do this. How do you go about doing that as a junior practitioner? So those types of things. I mean, I do provide feedback, but I'm mindful that I'm then going to go and sit on bar council and look at you dead in your eye, or elsewhere, and have these horrifically awkward moments if you've done a bit of a car crash. For one of my clients, it's really challenging to navigate. And people aren't used to it in a way that I am, where I had a client give me a full appraisal yesterday about what they thought, what they liked, what they didn't like.
And do you think that's the... Sorry, you go.
I mean, actually, the issues that we tend to find otherwise, I mean, I've had occasions with silks, actually quite a reputable, failing to deliver work on time. A person refusing to fly back to the Caribbean for a pre-booked hearing, which they had been booked and paid and the brief fee incurred for, and they would not get on that plane. And I have had, you know, I mean, these are the sorts of things that you feedback. Sloppy work. I've had Queen's Counsel who fell asleep in the conference with our client because he'd been burning the bridge, basically taken on too much work and just wasn't, you know, these are things that actually happen. And they're all from people from actually with pretty good reputations and pretty stellar chambers.
Could I just ask, with some of these really horrible stories that I mean, some of this is quite shocking. Do you ever make reports to the BSB about that?
Oh, it's very difficult because often the client won't want us to do that.
Mm-hmm.
And also, you know, it's very difficult because then you're going to have an investigation. You've got issues about the privilege of the communications and the privilege belonging to the client and not to us. So, I mean, there have been occasions where I've come very close to it, but as it turned out, the particular individual that we were concerned about a sexual harassment incident. The individual ended up being subject to a very significant investigation that then exonerated them, and then every female member of their chambers complained about the exoneration. So I think the message had kind of got out there, but that's the closest one we came to, which we thought this actually does have wider risk, and we were just concerned about if we hadn't reported it, that others were going to be very vulnerable. But because events intervene, but we certainly do consider it. But particularly around where we think there is risk to others. But it's very difficult around competency issues because there is a marked tendency of the self-employed bar to rally round and look after its own. And we are always concerned about our reputation in those circumstances. Hence why we try to use chambers' internal complaints if we can. But I say we don't often get very far with it.
No. And when it is a competency issue, often disciplinary processes are almost sort of too blunt a tool, really. That they deal with issues after the event. They don't address the underlying competence concern. So I guess one of the things that we'll be considering is whether there ought to be a non-disciplinary process for dealing with competency issues, which are designed to help someone to improve. And we might put some structures in place around that, you know, mentoring, training, whatever it might be, depends on the nature of the issue. And I imagine that's quite familiar territory for you in the employed setting. It's certainly familiar territory for all of us working in employment, where you have those supporting arrangements in place where there are concerns about your performance. I just wonder whether if we had something like that, we might get people more prepared to bring matters to our attention, because I think often the concern is, well, you're only going to take disciplinary action, and that's not really what we want. If there was a different route that we could take, do you think that might lead to people making more reports to the BSB?
And I think you need to address it, but I think there needs to be more than just making reports. You might want to borrow from financial services regulation and the on the certification processes, where, I mean, if you could have a system, for example, where the heads of chambers, as part of their regulatory responsibility, have to certify that they are satisfied with the competence and capability of everybody in those chambers, and to have a duty to positively report complaints, concerns, transgressions around competence. Because I don't think you can just have the system where everybody's self-employed, Therefore, nobody is actually having a regulatory responsibility for the competence of others. Heads of chambers have a really important role to play in this. And they shouldn't be taking on those roles if they are not willing to say to individuals that you are not good enough to be in these chambers. You are posing risks to our brand, you are posing risk to our reputation, you are a risk to junior members of these chambers, you're a risk to our clients. We will not certify you, or we require you to do further training, or we require you to undergo competence assessments. I think you could do it around that model, but I think there has to, ultimately, they're the only people who really know what's going on in their chambers.
Yeah, and that's not dissimilar to what you see in the healthcare sector around revalidation, where there is the requirement to be signed off by a more senior colleague as part of that revalidation process. Yeah.
That's very interesting, seeing all heads nodding. We do have that requirement, the duty to report around serious misconduct, but just being very clear about that, you all think that a duty to report around incompetence is something that you would want to see?
I think not just reporting, but a positive certification of competence. That every year you say, these people on this list, we are satisfied meet a competency criteria. So to encourage chambers to have a good clear out of the problematic people. And because the question then comes back to, well, if somebody does something, you certified this person as being competent. On what basis did you certify them? And this sort of attestation process and certification process has been quite effective in financial services. People are very nervous about putting their name on a certificate. Aren't they, Charlotte? I mean, you know, everybody's like, I'm getting queries all the time about how can I sign off on this person? Given what I know, I've had these complaints.
Who will volunteer to be head of chambers then?
No, but I mean, that's the same as the senior manager certification regime, right? I mean, you have to be in that role because you're willing to take on that accountability and responsibility, and you're taken through the mill in order to achieve that, and you have to go through all the relevant processes, but ultimately you have got to be a fit and proper person and be able to sign off. And I think that's one of the key things in the self-employed bar, is that accountability really stops at the individual, and if they don't really care that much, it doesn't matter, because everyone else in chambers just tends to kind of put it to one side. It's not my responsibility, and that's where I think the bigger issue comes. So rather than the reporting, which I still think is important for more serious issues, I think there has to be accountability. And you've heard even, I mean, some of the behavioural points as well. You know, that there are some things that Sarah's talked about that we wouldn't, in a commercial organisation, you wouldn't be there. You would not still be there in terms of diversity and inclusion if you were making comments that were unacceptable.
Yeah. Absolutely. Look, and we are pretty much out of time, but I think it's been really helpful to talk this through. I'd like to set something up again in the not too distant future, because there are some other issues I think it'd be useful to talk through, and also we'd like to come back to you as we sort of think through some of the issues that you've raised. But it's been really helpful, so thank you so much for giving the time. You've made some really valuable contributions, and I appreciate how open and honest you have been, because it's really important that we get to hear that. So yeah, thanks very much. I don't know whether Chris, Purnima, is anything you want to pick up before we close?
No, just thank you very much. If we have any further questions, would it be okay to come back to you? Thank you.
Nothing from me. Thank you so much.
Perfect. Thank you. Thank you very much. Thank you, Sandra, for organising this. Really appreciate it. So yeah, thank you all. Have a good evening.
Thank you very much.
Thank you.
Bye-bye.
Bye. Bye.